The Madlanga Commission of Inquiry has now entered its most consequential phase. Testimony this week from senior officials in the justice cluster has laid bare the extent of political interference in prosecutorial decisions and judicial appointments. The picture that emerges is not merely one of individual misconduct. It strikes at the heart of how South Africa's constitutional order is supposed to function. The Commission heard evidence that instructions were issued from within the presidency and senior ANC structures to slow walk or redirect investigations involving politically connected figures. One former National Prosecuting Authority executive described being told to park certain dockets until after the 2024 elections. Another witness detailed how shortlists for senior judicial posts were altered at the last minute to favor candidates with known political ties. These are not vague allegations. They come with dates, names and internal memoranda that the Commission has placed on record. Under the Constitution, the NPA must exercise its functions without fear, favor or prejudice. Section 179(4) is explicit on this point. The same document requires the President to appoint judges on the advice of the Judicial Service Commission, not to dictate outcomes. When political actors treat these institutions as extensions of party machinery, they do not simply bend rules. They erode the separation of powers that the entire constitutional scheme rests upon. What makes the current testimony especially damaging is its cumulative effect. Earlier phases of the Commission exposed capture inside the police and intelligence services. Now the focus has shifted to the courts and prosecutors. If both investigation and adjudication can be influenced from Luthuli House or the Union buildings, then the rule of law becomes conditional on political convenience. That is the opposite of what the 1996 Constitution intended. The Commission's legal team has been careful to test these claims against the evidence. Cross-examination has shown inconsistencies in some accounts, and not every allegation has held up. That is proper. An inquiry that simply rubber stamps every accusation would itself undermine due process. Yet the core pattern remains. Repeated attempts by executive and party figures to direct outcomes in matters where they had no lawful authority to do so. The implications reach beyond individual careers. If the Commission's final report confirms systematic interference, Parliament will face a direct test. The Constitution gives it the power to hold the executive accountable, including through impeachment or removal of office-bearers. Whether MPs will use that power or revert to party line protection remains the open question. Past experience suggests the latter is more likely unless public and institutional pressure is sustained. There is also the practical matter of remedies. Even if the Commission recommends prosecutions or disciplinary action, the same NPA that was allegedly compromised will have to pursue them. That circularity is one reason many legal observers now argue for a special prosecutorial mechanism outside normal structures, similar to the model used for state capture cases. Such a step would itself require careful constitutional design to avoid creating yet another unaccountable body. The rule of law is not an abstract slogan. It is the practical guarantee that power is exercised according to law, not according to who knows whom. The testimony before the Madlanga Commission shows how easily that guarantee can be hollowed out when political actors treat independent institutions as obstacles rather than constitutional requirements. The Commission's work is not yet complete, but the evidence already on record makes one conclusion unavoidable. Restoring the independence of the justice system will require more than new appointments. It will require political restraint that has so far been in short supply.